Well, a very, very good afternoon to you. Thank you for joining us here on a KTN News Desk on the 6th day of June 2017. Always a pleasure to have you tuned in. Let's start off from the courts, where the Court of Appeal is currently hearing an appeal by the Independent Electoral and Boundaries Commission seeking to overturn a decision by the High Court declaring presidential results announced at the constituency level as final. Now, the electoral body insists that it has to confirm constituency presidential results by returning officers before declaring them. In its finding, the bench ruled that IEBC cannot purport to vary, alter and confirm presidential results announced by 290 constituencies returning officers on the polling day, as this exposes the electoral system to abuse and malpractice by the Commission and its officers.
Also creates a nexus, again emphasizing the important role of a presiding officer in generating election results. It goes to the constituent standing officer who will conduct a tally. Once that tally is done, a declaration shall be made. So that, my lords, I now want to ask you, who is the Commission? There seems to be, in my view, a misapprehension as to who the Commission is. The Commission is a body corporate established by the Constitution, and it operates and functions through its officers. But where it is written the IEBC, it doesn't mean commissioners, neither does it mean a data entry clerk in Nairobi. It means the totality of all officers. But for purposes of an election, my lords, for purposes of an election, I refer you, my lords, to Regulation 3 of the Elections General Regulations. Regulation 3, the Commission donates its powers to conduct elections to its returning officers. In Regulation 3 of the Elections General Regulations. That power having been donated to returning officers, a data entry clerk at the Commission or any other person working at the Commission cannot purport to execute the functions of that delegated power. Elections, I do submit, my lords, are conducted by designated officers, not any other person. Such that even a commissioner of the IEBC, even a director of the IEBC, does not become an election officer unless he is gazetted as an election officer. And that is the language of the Constitution. Presiding officer and returning officers are identified in the Constitution. Such that if there is any other center that will wish to have an engagement with these results, that center must find accommodation in Article 86, either as a presiding officer or a returning officer. Having said that, my lords, I wish to address you on the next point in Article 81. Article 81 sets out the principles of the electoral system. It applies to the elections. It applies in the conduct of elections. Amongst the principles captured include the following: transparency, accountability, as part of the principles of the electoral system. When elections are conducted under Article 86, Political party agents are present. The particular voters are present. Observers are present. Members of the public are also present. The locality where the election is conducted, it allows participation by those voters in that locality. And Article 86 requires, when we say we read the Constitution as a continuous document, it infuses the Article 81 on transparency and accountability. The local voters are present in that location. By the time they leave the stations and go home, they all know what those results are. The results are publicly announced to them. And in buttressing that point, my lords, I will refer also to Regulation 79 and Regulation 83 of the Elections General Regulation. And this comes in play when we define an announcement and a declaration. Announcement is publicly made, they hear and take note. If you read Regulation 79 and Regulations 83, upon an announcement, there is a declaration for each style of election at that level. And that declaration is made in the forms provided. The declaration is made in the forms provided by the Commission. And those forms, my lords, and I will read for you 83 1C. The returning officer shall complete Form 34 and 35 set out in the schedule, in which the returning officer shall declare. The returning officer shall declare, as the case may be, the total number of votes cast for each candidate for referendum site in each polling station, that's the referendum, the aggregate number of votes cast in the respective electoral area, the aggregate of number of rejected votes, such that a declaration is done in the forms. And once that form has been filled by the election officer, it is signed by the candidates. 79 again and 82. Candidates must sign the results declaration form. They confirm that whatever is included is actually a reflection of the votes that have been publicly announced. Now, my lord, having made such a declaration in the form, can it again be open to another level to vary, to alter, to confirm those same forms in the absence of the parties who signed the forms? Is it possible? I respectfully submit that that will be an absurdity. If there be any need to vary, to confirm, to alter, or to change any of the indicated results in the forms, it must again involve all those players who have signed to the form. So that if you have a regulation, like we did in Regulation 83 and Section 39, that makes the form provisional and subject to a confirmation at a particular level where these candidates, these agents are not present, then that is unconstitutional. And that, my lord, is what the Superior Court was confronted with, and we did so fine. And my lord, I refer you to the Joe case found in our list of authorities at page 16 and 18. In that case, at page 18, the court says declaration takes place. Declaration takes place at every stage of tallying. For example, the first declaration takes place at the polling station, the second declaration at the constituent standing center, and the third declaration at the county standing center. What are we saying? The Supreme Court in the Joro case rightfully so says that when that form is filled at the polling station, it is a declaration. When another form is aggregated at the constituency level, it is a declaration of the results at that level. And that having been the case, if there is a desire to change, to alter, to confirm any of that results, then the same procedure ought to be complied with, involve all the players. But if it is not possible, the Constitution has equally provided for another avenue. The elections court is an avenue that is open to all players. They can come and litigate any alteration that needs to be made on the results once they have been declared. This petition sought to have, for example,
the hearing there, the Court of Appeal proceeding ongoing. Our reporter Mrimi Mwangi is there, even as the lawyers give out their submissions on this case that was referred to the Court of Appeal by the IEBC after the High Court ruled that the results announced are final. So this is something we could continue to follow up on. It's a big story today, and we'll definitely be giving you more details in our subsequent bulletins.